These cases are not about content. It's not about the content. It's about Meta's deliberate design choices for these platforms. These platforms were changed to make them deliberately addictive to children. They want to hook kids while they're young.
Is that users don't give up their personal data in order to gain access to the platform.
Pages 1 through 3, case 886110, State of Nevada versus Meta Platforms, Inc. Then there was the subcases consolidated therein. Counsels for the state, do you want to go through all your appearances, please?
Yes, Your Honor. Michael Gayan with Claggett and Sykes, and with me here in court today, we have Mr. Mark Kruger from the AG's office. Also from the AG's office, we have Raquel Fulgham and Sam Feely. Yeah, sorry. A lot of folks. We also have Randall Jones from Kemp Jones, Sean Claggett and Will Sykes from Claggett and Sykes, Will Lemkel, and also from Mr. Lemkel's firm is Chris Terzo, and from Claggett and Sykes is Richard High. They're all observing, and also on the Zoom, observing only, we have Brian McMath, Dory Tester, Cindy Jing from the NLG, and Matt Bush and Brian Moore from the NLG firm, and Anthony Walsh from the AG's office. Oh, and Michaela Howeiler, sorry.
I'll be happy to.
Oh, and Phil Carlson, I'm sorry, sitting right next to me.
I kept looking that way, but okay,
Yeah.
thank you. Okay, counsel for defense.
Good morning, Your Honor. Tammy Peterson for Meta. With me here at the front counsel table, Timothy Hester. He is admitted pro hoc vice. Behind him is Mr. David Sneed, also admitted pro hoc vice, and then also present here on behalf of Meta is Dan Waite from Womble Bond, something, I don't know. and Dan Polsenberg also from Womble Bond. Also seated in the courtroom is Patrick Nutter from Covington. He's not admitted in this case, he's just observing.
Remotely?
We're all ready, Your Honor.
No, anybody remotely that you need to introduce?
I don't think we have anybody remotely today, it looks like.
No worries. Okay, thank you so much. Okay, so what we have on today is we have defendant Meta Platforms Instagram's motion to dismiss the state's first amended complaint. The document applies to all cases as stated in the caption pursuant to the prior stipulation, document 273, plaintiff state of Nevada's opposition, document 279, and that was timely filed pursuant to stip and order, document 268. Defendant Meta Platform and Instagram LLC's reply, document 280. And remember today, because remember there's a confidentiality stipulation, this can be fully recorded pursuant to a prior media release that was allowed. So just remember, if you're getting to anything that you need to be sealed or should not be part of any A, public record, or B, actually being simultaneously recorded, you need to let the court know in advance of reminding you, because A, we've got some new faces, and B, it's been a few weeks since I've seen you.
Your Honor, Michael Gayan for the state. I believe we've revised the redactions in these complaints to just be certain non-executive level employees. So I don't plan to talk about those folks, and I don't think there's any other redactions that would slow us down.
I think that's correct, Your Honor. I think at least for purposes of this motion, we should be pretty good about what's been sealed. I don't think we're going to have to request anything be closed today.
Okay, appreciate it. Just want to give you a heads up. Okay.
I do have one housekeeping matter,
Sure.
if I could address. We've talked to the state and they've agreed. We're going to divide our argument a little bit among some of the lawyers here by subject matter, if that it would work. So that is our plan for proceeding today.
And by prior agreement, I believe it was a half hour each side. Is that correct? Not including court's questions, which is why we were allocated the hour and a half in case the court had questions.
Your Honor, Michael Gayan for the state. Yeah. That's my understanding on the time.
60-second minutes.
Yeah, 60-second minutes, standard minutes. And the state is prepared to keep its remarks to that amount of time or less, and does not have objection to Meta splitting the argument however many ways they want to split it.
I'm not sure that we had a formal agreement of a specific time division, so I just want to be cautious with that. If I go over, I don't want that, but we understand the court has some time limits and we are going to abide by those time limits. So we want to make sure you have some time at the end to question. So I think that will work, but I just don't want anybody clocking me and saying, hey, you're 30 minutes and 30 seconds. We really didn't agree to that specific time frame.
Okay, Mike, the court's recollection when I set the special setting, knowing I would be in trial, is that it was going to be 30 minutes each
That's
side
fine, then,
and
Your Honor.
allocating.
We have agreed to abide by your, so if it's 30 minutes per side because of the court, that's fine. We'll abide by that.
That was my recollection when I said it this way, so that to make sure to do it and then balance that with the other cases on my docket, specifically a jury trial that's about to go into closing arguments. Okay, well, once again, we'll see how it goes with regards to flow. And if I have an objection to somebody going over, I'll address that at the time if I get, okay. So since it's defendant's motion, feel free to go for it. Now, one caution I will say, and actually this is brought up in the reply is, folks, please don't go back to other cases and incorporate something that's in 10,000 plus pages in a variety of different cases that happen to be before this court. You got to be specific on what you're asking me to rule on and what your citations are. And that's not to anyone in specific. That's just a generality, okay? Because I can't go fishing through, nor is any judge supposed to, right? The famous Posner quote. Go fishing, sniffing truffles, however you want to say, and try and determine which part of which pleading or what exhibit to what appendix in another case that happens to be before the same department would apply here. And I presume as very sophisticated litigators, I really didn't need to say that, but making sure, because I appreciate this is a larger case and sometimes people do that. Thank you. Go ahead, please.
Good morning, Your Honor. Timothy Hester on behalf of Meta. Sorry for the court's voice. I've had some of the same problem this week. As Ms. Peterson mentioned, we're going to be splitting the argument. I'm going to begin with parens patriae, and then Ms. Peterson is going to cover the Deceptive Trade Practices Act claims, and Mr. Sneed is going to address product liability. I'll then come back to speak about unjust enrichment and negligence. Before I turn to parens patriae, I just wanted to raise a point at the threshold that Meta reasserts its position that the FACs should be dismissed in whole or in part based on lack of personal jurisdiction, that the claims are barred by Section 230 of the Communications Decency Act, and that the claims are barred by the First Amendment. We recognize the court has already rejected these arguments, and we did not want to burden the court with a new round of briefing. So we understand that the court's ruling would apply here, but we did want to make clear that we continue to hold the position that the FAC should be dismissed on those three grounds. But we understand the court's ruled on those already, so we didn't go back to that with another round of duplicative briefing. So let me begin with parens patriae. In the TikTok litigation, which we have cited in our briefs, the court ruled that the state does not have parens patriae authority to assert claims for product liability, unjust enrichment, or negligence. And the state never mentions and does not address this court's TikTok decision on this precise issue. And we submit the court should follow and apply that TikTok ruling here. The state is asserting the identical claims as in the TikTok case, and the court should reach the same result. And let's talk a bit about why the court should reach the same result. The question of the AG's authority to assert parens patriae claims is a function of Nevada statutory law. The Deceptive Trade Practices Act explicitly provides that the Attorney General can assert parens patriae claims. There is no comparable grant of statutory authority to assert other kinds of parens patriae claims, in particular to assert product liability, unjust enrichment, or negligence claims. And the Nevada Supreme Court in the Ryan v. 8th Judicial District Court case that we've cited in our papers, 503 P. 2nd at 844, made this point very clearly. The court said, quote, "The powers and duties of the Attorney General are to be found only in legislative enactment. And there is no statute that provides authority for the Attorney General to assert these three categories of claims." And the court's prior ruling on this exact issue in TikTok reflects this reasoning and the rejection of some generalized parens patriae authority for the Attorney General. The state does not answer this point. Instead, the state largely relies on federal cases involving a different issue of when a state has standing to assert a parens patriae claim in federal court. That's not the issue here. The question is one of state law, not federal law on standing. And so the state's argument that it's seeking to vindicate quasi-sovereign interest, quoting the SNAP case and others, is beside the point. The Nevada Attorney General can only seek to vindicate the rights that the Nevada legislature has given it power to vindicate. And these legislative limitations on the AG's parens patriae authority are controlling here. In addition, courts do not recognize parens patriae authority, whereas here, private parties can seek similar relief in private actions. And we cited and quoted from Missouri ex rel. Coster v. Harris in our briefs. Courts, quote, courts have recognized that parens patriae standing is inappropriate where an aggrieved party could seek private relief. And that point fully applies here. Private parties are asserting the same claims against Meta that the state's raising here. So to sum up, the AG lacks standing to assert these parens patriae claims for product liability, unjust enrichment, and negligence. Those claims should be dismissed on this basis. And that applies to counts 3, 4, 5, and 6. Later on in the argument, we'll address other reasons why those counts should be dismissed, but the court doesn't have to reach those other arguments because the state lacks the authority to assert them as parens patriae claims. Unless the court has questions about that, Your Honor, I will turn it over to Ms. Peterson to cover the Deceptive Trade Practices Act claims.
I do not have any questions. Thank you so much.
Morning again, Your Honor, Tammy Peterson for Meta, addressing the deceptive trade practices claim. Your Honor, I'm going to highlight just a few things that were in our brief in the interest of brevity. And if you have any questions, I know the court has some issues today with voice, so flag me down.
I've had no challenges in hearings and trial all week for people hearing me, understanding me, and glad to ask questions if I do have any, but thank you so much. Curtis.
Thank you. Your Honor, the court had previously dismissed these deceptive trade practices claims. And the order that the court entered says the court holds the state has not adequately alleged how the transactions at issue here are goods or services for sale or lease as required by Chapter 598, or that there should be an extension of current case law. Now, the court deferred ruling on all of the other prior bases that Meta had filed its motion to dismiss on these deceptive trade practices claims. And I'm going to address a couple of those later, but I want to focus first on this this concept about what the state has alleged about how the transactions at issue are somehow goods or services for sale or lease, because they have not met that requirement even after the amended pleading. The Nevada Deceptive Trade Practices Act only applies to goods or services for sale or lease. All of the complaints, the Messenger complaint, the Facebook complaint, the Instagram complaint, they all say, like all social media platforms, Messenger or Facebook or Instagram does not charge money from its users for access. That is a critical part of this idea of whether or not there are goods or services for sale or lease. Now, what the state does in their argument and their opposition is they say, hey, we want to talk about consideration. And we think that consideration sort of encompasses this idea of collecting data, okay? And, Your Honor, I think we have shown in our brief that courts have rejected this idea that a social media service use of consumer data in providing a free service, that could somehow be viewed as an exchange of consideration. The INRI Yahoo case that we had cited in our brief says the mere transfer of users' personal information doesn't render the use of a free service a purchase or lease of that service. That same case even said, you know, the fact that defendants store personal information and use it for advertising doesn't mean that plaintiffs purchased or leased some good or service. The case from the Central District of California, the SNAP case, you know, they also said, you know, exchanging personal identifiable information for use of a free social networking application doesn't constitute a purchase or lease under California's version of the act. The Tiny Lab case that we had cited from New Mexico, again, the free download of a social media app was not a sale, lease, rental, or loan of technology, but even though it collected data that tracked users' online behavior. Now, the state points to another case that was before this court, and they point to.
I'm sorry, somebody's vibrating. I can hear it. I'm going to just turn them off vibrating. Sorry.
No problem. I'm glad we got that solved because I want to make sure that you got that. So the state points to another.
That sentence because it was, I mean, I could hear the vibration.
Oh, you
Let's
get
say
every,
something.
I couldn't hear it, so I'm so I don't know where it's at. I will stop them too if they're interrupting me. So the state points to another order that this court entered in another case, and it's the TikTok case.
One
And-
colleague wants me to apply to this case and for certain facts, for certain causes of action.
Well, Your Honor, I think that
So we're talking the same case, right?
we are talking the same
Okay,
case,
go ahead.
correct? But I think that the state is trying to, what's the Shakespeare phrase? The devil can cite scripture for his own purpose. I mean, I think the state's trying to say, hey, we have this order that says that a user data is sufficient for goods or services for sale of lease, and that's it. Now what they are missing here is any sort of respectfully, any sort of detailed analysis about this. They say that there's this consideration because data is somehow being collected. Now, the Nevada Supreme Court has said that consideration is the exchange of a promise or performance that's bargained for by the parties. And in order to have something that's bargained for, both parties need to be able to exchange something of value. And what the state doesn't have, and what we can't find, is any case where a Nevada court said that user data collected solely from the use of a voluntary free service, that user data that is collected somehow is sufficient to mean consideration. And here's the issue with what is in the TikTok order and what the state is trying to argue today, is that users don't give up their personal data in order to gain access to the platform. They don't do that. Meta collects information as users engage with others on the platform, but the information only exists to the extent that a user engages. There is no exchange that is required for users to use the platform. The user is given the same access regardless of what activity data they end up creating. They still have access to everything. So there's no exchange, there's no bargain for exchange. The state tries to deflect a little, and they talk about some features on Facebook and Instagram called shops, where advertisers can create virtual stores. But these allegations are only about transactions that can occur among users and businesses on Meta's platform. They don't say then the state can't allege that Meta transacts business with its users conditioned on using these shop services. They don't say that. They can't say that because it's not a requirement to use the service. They say the same thing about MetaPay. They also raise something called stars in their opposition, but that's not in their pleadings, so that should not be considered by the court. It's not in any of the First Amendment complaints. You know, I've looked at the TikTok order, and I'll be candid, Your Honor, I had read your transcript, the transcript of the hearing before the order came out, and you know, I've looked at the order, but the order itself doesn't address this issue, whether there's a sale or a lease under the statute. It just says that a sale, you know, it cites the statute itself. Says, you know, any sale, offer for sale, or attempt to sell any property. So the term sale is sort of defined by saying, well, it uses the same word, sale, sale, sale. But sale in its plain and ordinary meaning, which is what the Nevada Supreme Court directs us to look at. Sale means the transfer of ownership of or title to property from one person to another for a price. That's the Merriam-Webster dictionary that we cited in our brief. Black's Law Dictionary says, well, sale is the transfer of property or title for a price. There's no transfer of ownership or exchange of property in a user's free use of Messenger, Instagram, or Facebook. And that should be the end of the inquiry. They haven't alleged it. There's nothing that they could allege. And that is a requirement under the Act. We had raised some other issues with regards to the Deceptive Trade Practices Act that we had addressed earlier, and as I indicated in your prior order, those were not ruled upon, so we have not waived those, and we are arguing that the Deceptive Trade Practices claims are also still subject to dismissal. For several reasons. Number one, Meta is exempted from liability as a publisher. This was not ruled on in the court's prior order. The state's complaint alleges that Messenger and Instagram and Facebook are all used to send messages and exchange photos. The state's complaint basically alleges that they are a publisher. We have also raised the issue of Rule 9B under the Nevada Rules of Civil Procedure, that these claims should be pled with particularity. We have cited Brown versus Keller, the preeminent case about actions involving fraud and requiring them to be stated with particularity. These are the time, place, identity of the parties, nature of the fraud. Federal cases looking at these kinds of Deceptive Trade Practices claims have said that they are subject to dismissal if they're not pled with particularity required. Now, the court briefly addressed this issue in that TikTok order, and the court cited to
Counsel, I'm gonna have to stop you. Oh,
okay.
this is not TikTok. You don't represent TikTok, right?
No, I don't,
Then
but I
please, and that's what I
Fair
tried to caution everyone at the beginning.
fair enough.
This is your clients for this case,
Fair enough.
with this case number, 886-110, okay?
Yes, that's
And
correct.
you can't take a case that was argued by different people with a different complaint, with different factual allegations, with a very different, at least articulated to this court. You all aren't TikTok, okay?
Right.
I mean, if you are, let me know. I don't think you
No,
purchased
we-
TikTok.
We are
At least
not.
publicly available information doesn't seem to be that way, whether they can or cannot operate in the United States. Stay tuned, but that's not before me. Okay, so you can't keep, you're switching around, order this, order that, whether you're talking about an order in this case, or you're
Right.
talking court's order in TikTok, whether you like or don't like my order in TikTok.
Yeah,
The attorneys
and
can
I-
do what the attorneys want to do. They've done what they wanted to do. And that's the appellate court's decision with regards to that. Can I finish, please? 'Cause
yes, Your Honor.
I
I'm so
really
sorry.
need you all to focus on this case, this complaint. By definition, it's a motion to dismiss your complaint. If you all come in as counsel as TikTok, I'll welcome you into the court as counsel for TikTok and whatever future hearings I have. Okay? But This is different parties in a consolidated case regarding different platforms. And I don't need to highlight at this moment the many differences that were articulated to this court when TikTok was argued how it's not like Meta. Different things, right? So folks, please focus on the case before the court. If you want a ruling from the court on this case.
Thank you, Your Honor, and my apologies for that. I'm literally addressing what the state quoted in their opposition brief, and I think they've tried to rely on that. So
Both sides
I would
try to
address-
rely on different
Fair.
parts that you like, okay?
Fair.
I fully appreciate it's fair game, okay? That people can say, well, Judge, you might have ordered this as analogous. But to start directly saying, well, in the TikTok order this and that, okay? If you disagree with the TikTok order, you gotta be counsel for TikTok and take their motion for reconsideration, whatever, their deadlines. If you want to say it's analogous, feel free to do so, but remember, district court judges, right? An order from a district court judge is not binding, even if it's the same district court judge. Okay? While I do appreciate quotes like foolish inconsistencies might be hobgoblins of little minds, there may not be a foolish inconsistency if it's a different set of facts argued to the court in different law. Okay, thank you. Please proceed.
Thank you. But some of the cases that the state did cite to say that they don't somehow have to comply with Rule 9B was one of the cases was the Betzinger case from the Nevada Supreme Court. And I just want to point out that that case does not stand for the proposition that a deceptive trade practices claim alleging misrepresentation and fraud doesn't have to have the particularity pleading requirement of Rule 9B. What Betzinger says is that at trial, there's a particular legal standard of proof that must be met in order to prevail on a claim. That has nothing to do with pleading. The other case they cited was the Poole case. That again does not say what they'd like it to say. That addresses only the summary judgment standard for a Nevada deceptive trade practices claim. It does not stand for a proposition that in pleading a claim like this that they've pled that about, I guess, misrepresentation, that they somehow can evade the pleading rules of Rule 9B. The federal cases we cited say that those do apply, and so we are again asserting, Your Honor, I think the Nevada Supreme Court needs to settle this once and for all. But I think it's really hard for me to understand why a common law fraud claim would have to be alleged with particularity, but a claim under this statute that also somehow alleges these fraudulent acts doesn't have to be. And I think that that is what the point of the pleading rule is. I know I'm running out of time because I want to give my co-counsel an opportunity to speak. So if you have any questions, I'd be happy to answer them, but I'll reserve any other time we have in rebuttal.
Do not. Thank you so much.
Thank you.
Good morning, Your Honor, and may it please the court. I'm David Sneed on behalf of Meta. I'll be addressing the product liability argument. The parties at this stage agree on the analytical framework. The court must apply under Nevada Supreme Court law, the second restatement of torts. And the Schuler case that both parties cite established that. The disagreement that the parties have at this juncture is whether or not the court must consider, address, and rely on tangibility as a concept. And the state tries to read that out of the restatement and the Schuler case, but it's right there in the analysis that they give. In the Schuler case, it explains when relying on section 402A of the restatement, there's a non-exhaustive list of tangible items to which the doctrine applies, and then goes through those examples. We don't disagree that the Schuler case recognized that there is a case-by-case analysis that this court is required to engage in. But in doing so, the Nevada Supreme Court repeatedly came back that in applying that case-by-case analysis, the court must use as guideposts the things that are in that section 402 list of tangible items. In fact, the Schuler case said, simultaneously using the non-exhaustive list of items and goods in comment B as guideposts to ensure adherence to the doctrine's stated purpose. So there's no basis under Nevada law to read out tangibility when that is the analysis that begins the process of figuring out what is and what is not a product under product liability law. To reject it when all of the items that are listed there are tangible. It is the one common element for all the items listed in the restatement. If to reject that would be beyond what Nevada Supreme Court law would allow. And in fact, even the Schuler case, while not accepting the third restatement's strict definition, says that a court could find useful the definition in the third restatement that says a product is tangible personal property. While not accepting that and making that the rule forever, saying we still have to do this case-by-case analysis, that is something that the Nevada Supreme Court has recognized as something a court could take into account when making a decision about whether a new item is a product or is not a product. Now, in this case, the state's arguments really boil down to three things that I'll quickly address because our briefs kind of address this in large part. One, it's the policy-based analysis in the second restatement. Two, it's the Lemon case. And three, they rely on statements by fact witnesses and meta documents. On the first, none of the three policy objectives that are listed in the Schuler case as being the analysis for whether it is a product or not are met in this case. And really, to boil it down to really one point, the reason for that is because Meta does not manufacture, put into the stream of commerce, a product in the way that is expected under product liability law. The first one, promoting safety by eliminating the negligence requirement, strict liability wouldn't promote safety here because this is not a car with a faulty steering wheel. The item that purportedly caused harm is not something that was created or manufactured by Meta, it's the third-party content on Meta's services. There is no harm without it. All of the claims, whether under any of the instrumentalities that are identified and alleged by the state, really come back to the harm that's arising from individuals from seeing third-party content, and that's not something Meta manufactures. That's the underlying principle behind strict liability law. We want to make it easier for people to sue the manufacturer without having to prove negligence. We want to spread costs from products to the manufacturer seller. We want to remove concerns about plaintiff's ability to prove negligence. All of these are based in the scenario where the manufacturer is the thing that's actually doing the causing of harm.
Pause you for a quick second there. Okay, I will fully disclose, to my knowledge, I don't have an Instagram of somebody unless somebody's hacked me and created one that I know. Okay. But to do Instagram postings, right, or little Facebook videos and things like that, isn't that all a lot of that self-contained when somebody can just go on and so that it can be created like your something to be Instagram. Okay, sorry, I don't even know the lingo. My kids are not young enough that they tell me this. Selling products through Instagram, right? It's Instagram promoted, or it's an Instagram favorite, or it's a this or that. Don't those tags in that creation is available through Meta, similar to there's videos sometimes posted on Facebook, separate apart by Facebook messengers, maybe a little bit different here. But are you saying, or somebody has to create it all themselves, and then isn't the intellectual property such that the only way that you're going to see it if you're in another city or state, okay? Spadey Peterson wants to post something about one of her kids, right? Or is because Meta makes it possible through allowing that to happen, right? Facebook out to the world or whatever. I don't remember the original thing that came out.
Meta does provide the service for people to be able to see what other people are posting. That's true. So to get on Facebook, you're able to see what other people have put forward.
But it's the posting, right? They can't post unless Meta lets you post. Right?
Yes.
Okay, hypothetically, I would never do this because I'm in the middle of a hearing, right? And I don't do up counts anyway. Hypothetically, if one of you decide not to pay attention, and wanted to go click right now on Facebook, couldn't you post something? But if you didn't have a Facebook account, it would not show up on Facebook, right? So that your colleague sitting right next to you, or what happens oftentimes, right, in teens doing whatever they're doing, sees things automatically, or you do your little Insta, whatever you're doing.
So it's true, any one of us that had an account would be able to go on and actually post a video or a picture, and other people would be able to see that. If you didn't have an account, you wouldn't be able to see the information that's posted. That is true, but I don't think that changes the fact that the harm that is being alleged arises from a focus on the content that's being posted and not on Meta generated. If it was something that Meta actually created and sold and sent out, it'd be a different case. But that's not what the case is here. Meta is not generating and creating these items. Other people are, and that content is what's being seen by others. And then even in the scenario where you wanted to say that, oh, that's analogous, well, what we'd have to look at in terms of the analysis the Schuler Court gives is also whether it is tangible and is like the list of things that are listed in the second restatement. And because it's not akin to that, it's not the same type or even anything like an automobile or something of that nature, even if you were able to leap over the first hurdle and say, oh, well, we think it's something akin to a manufacturer like that, you'd also have to look back at the guidepost that the court gives, and it doesn't align. Even the features, now the way the state wants to get around it is saying, oh, the features themselves are the cause of the harm, not the content itself. But any of the features that they point to are similarly intangible. And there's a good reason why strict liability doesn't apply to them. And courts nationwide have said that when we're looking at information, thoughts, ideas, messages, individual postings, things like that are in games, movies, and website materials, we've opposed extending product liability to go that far because it's not the same thing as what is in the restatement. I'll briefly just say, we've made the argument before that Lemon doesn't address this case. We've said that in our brief, and I'll rely on that. And any of the statements that they rely on from witness statements or documents that Meta has produced, none of those are applicable to the legal question. The question of law this court has to decide whether or not under Nevada Supreme Court law, Facebook, Instagram, or Messenger qualify as a product.
What are they then?
They are social media services that allow people to be able to communicate and connect with other people online.
So from your interpretation. So where are social media services addressed in the second restatement of torts?
They are not addressed in the second restatement of torts. What it provides is a definition of what a product is by reference to tangible items. And this is not akin to that. And so it isn't listed in there. It's not based in that.
No, I mean, it was kind of an easy question because we all know it's not, right? Because when the second restatement of torts was written. But so are you saying because social media platforms aren't in the second restatement of torts, they can't be subject to any tort?
Well, I'm saying that the analysis that the courts give is to say, look at the second restatement of torts, consider the policy objectives, but be guided by the list of things that are there, the tangible list of things that are there when defining in the future what qualifies as a product or not. And I think that what our submission is that, yes, technology changes and there are new things that are happening, and this is a new technology that happened after the restatement, but it doesn't change the fact that the analysis doesn't encompass going beyond tangible items. And there's good reasons for that, because strict liability, the nature of the type of law it is such that the focus of it as it developed was on tangible goods that cause harm. There are other ways that people could make claims against companies, and we have negligence claims in this case and other claims, but strict product liability was made for a certain reason, and the restatement restricts that to tangible items.
Appreciate it. Thank you so much.
Thank you, Your Honor.
Next, go ahead.
Your Honor, I would be very brief on these final 2 points. I wanted first to touch on just enrichment count 6 of the FACs. I already discussed the parens patriae issue, and that's a separate basis for dismissal of the unjust enrichment claim, but I wanted to speak to some other points as well. The court previously dismissed this unjust enrichment claim. It held that the state had failed to adequately plead, quote, how Meta was unjustly enriched at the state's expense, as opposed to why Meta was allegedly unjustly enriched at others' expense. And the court granted leave to the state to amend, and the state's FACs do not amend this unjust enrichment claim. So the court's prior reasoning should control again. So that's one basis for dismissing the unjust enrichment claim, even beyond parens patriae. There's also another reason that this unjust enrichment claim can be rejected as a matter of law, even beyond the court's point that there's no allegation that Meta was enriched at the state's expense. And that is based on the fact that there is a contract between the users and Meta, as the state admits and alleges in its complaints. It alleges that every user who creates an account enters into a contract with Meta. And because the alleged conduct is covered by a contract, the state cannot assert an unjust enrichment claim. And that proposition is established by the lease partners case from the Nevada Supreme Court, 113 Nevada 747 at 755. I'm quoting, an action based on a theory of unjust enrichment is not available when there is an express written contract, because no agreement can be implied when there's an express agreement. So that is yet a further reason that the unjust enrichment claims in the FACs should be dismissed. Finally, I wanted to touch very briefly on the negligence point. I argued previously that the state does not have parens patriae authority to assert a negligence claim. That should be dispositive of the negligence claim. We will otherwise stand on our papers on that issue, Your Honor. Unless the court has questions.
I do not.
Okay,
so
thank
much.
you.
Okay. So who's arguing this for the state, or is it a combination? Are you taking all matters, or is there a combination?
Your Honor, Michael Gayan for the state. I'll be taking all matters.
Okay, go ahead.
All right. Good morning, Your Honor. I'd like to put my notes. I'd like to kind of reset the table before I get started, Your Honor. I know the court is well aware of this, but we are here on a 12B5 motion. The 12B2 is over. Personal jurisdiction, section 230, First Amendment, Meta lost. The court ruled on it. That hasn't been reasserted. There was a writ. The Supreme Court denied all three writs, and we're back here today. And this is a much narrower set of issues than what we argued back in October on these similar motions. So I just want to emphasize that we're here on a 12B5 notice pleading buzz stew standard. No set of facts possible to support these allegations. The state has filed 3 complaints against Meta that are well over 100 pages each. The state has amended extensively those complaints after the court made its rulings late last year, and the state has addressed all of the court's concerns. Frankly, Your Honor, it is problematic that Meta, throughout its moving papers, has misrepresented the scope of the court's prior rulings. So the state addressed that in its response. Meta has also misrepresented the scope of the state's allegations and the scope of the state's amendments. So I would encourage the court to look closely at its prior orders and the state's actual allegations, and not what Meta says the state has alleged. And I know from long experience in Department 31 that Your Honor does that and takes your obligations very seriously before dismissing a cause of action. So with that, I think what I'd also like to do is start with negligence. And on that point, Your Honor already entered orders denying Meta's motions to dismiss in all 3 cases as to the negligence cause of action. And the Litchfield case from last year, the Nevada Supreme Court extended the law of the case doctrine to district courts. and made it clear that barring a substantial change in the evidence of the law, district courts should not switch their rulings. And here we are, just one round of motions later with no changes other than the state adding substantial material new allegations. There's no basis for the court to revisit its orders denying Meta's motions to dismiss the negligence cause of action. So hopefully we can dispose of that quickly. And Your Honor, before I get into my other comments, maybe I'll try to shortcut some of this because this is Meta's motion and it's their burden to convince the court that there are no set of facts that could ever support the state's causes of actions. I'm going to ask if the court has any questions or concerns about the state's amended pleadings or briefing, and that'll maybe help me focus my comments.
I was gonna wait to listen to see how you were addressing this Deceptive Trade Practices Act and the sale and lease issue.
Okay,
What that was going to be, I needed to hear what you were gonna have to say, and I was gonna potentially ask a question if that's one of the areas you think might be a question.
absolutely. Your Honor, I will start with the
And the
deceptive trade.
publishing, and the publishing aspect as well.
Sure, I'll get to the publishing. Maybe I'll just tackle that first because that's so erroneous. Meta is not a publisher. Publishers under the statute are engaged in the dissemination of information or reproduction of printed or pictorial matter who publish, broadcast, or reproduce material without knowledge of its deceptive character. Your Honor, from the prior briefing and argument and the court's rulings on Section 230, these cases are not about content. It's not about the content. It's about Meta's deliberate design choices for these platforms. These platforms were changed to make them deliberately addictive to children. They want to hook kids while they're young, get them on their platforms, get them addicted to logging on and scrolling forever, and the harms that those addictive design features cause. This is not a content case. This is not a publisher case. We dealt with that in First Amendment, Section 230. That is in the rear view. That has nothing to do with this case. I believe the court's already found that to be the case in its rulings on Section 230 and the First Amendment. This isn't about content. We're talking about Meta's own conduct, knowing and deliberate decisions to institute design features to hook children and frankly everyone into using their products more and more and more. So this is not a publisher case. This is about Meta's own deceptive conduct, own harmful design features, and we have nearly 30 pages of allegations on material misrepresentations about the safety of those products as well, and I'll get to that a little bit more later. In terms of the Deceptive Trade Practices Act claims, Your Honor, I do want to emphasize, I'm going to start with the fact that this is a remedial statutory scheme. And the Nevada Supreme Court has said courts are to broadly construe remedial statutes. So that is the lens through which the court should be reviewing the state's Deceptive Trade Practices Act claims. And Your Honor, I want to emphasize one other thing. This, after the court's ruling on the prior motions to dismiss, Meta has taken the position that the state's motion for preliminary injunction and the evidentiary hearing is completely moot because the court dismissed the Trade Practices Act claims. And that was the primary basis for that motion. So Meta is hoping to not only get out from under these causes of actions in the three cases, but it's hoping to avoid any of the injunctive relief that the court and the parties spent significant time on last year, and that is still pending before the court for reasons that the parties have agreed to, but that there's a motion to supplement the record that we've kicked off, but that is still an open issue that the parties, not that the court is supposed to be doing anything with it right now. The parties have stipulated to moving that out until after this ruling. But I just thought the court should be aware of that issue and that Meta is hoping to get dismissal of these causes of action so they can avoid the entire evidentiary hearing and potential injunctive relief. So with that, Your Honor, I heard counsel argue that the Betzinger decision on 9B, that Betzinger doesn't deal with 9B. Well, I think it does, because if you look at Betzinger, and I brought a copy, there's a heading that says Deceptive Trade Practices Act claims are considered under a preponderance of the evidence. And I'm confident, I don't know if it's in your instructions that you'll be reading later today, but a fraud cause of action is clear and convincing evidence. It's not preponderance. And so if NRS 598 claims are subject to 9B and fraud standards, then they would also be clear and convincing, but they're not. Betzinger says they're not. They're preponderance. And so notice pleading, Rule 8, all applies, 9B does not apply. And sure, Betzinger doesn't say that directly, but it's the only logical conclusion from Betzinger. And we've briefed it otherwise in our papers. But Your Honor, I just briefly, even if 9B did apply, the state's complaints are extensive and detailed. And frankly, if you look at Meta's motion to dismiss and reply, they just say in conclusory fashion that the complaints don't meet the 9B standard. They don't say why. They don't say what's missing. They don't analyze anything. They don't say the who is missing, the where. They just say 9B requires the who, what, why, when, where, and the state's complaints don't do that. That is clearly insufficient to carry their burden on a 12B5 motion. And there's really nothing there for the court to rule on. It's just a conclusion from Meta that's improper. And that's in the reply, pages 7 and 8. In terms of goods or services for sale or lease, we've put these in our papers on the new paragraphs that were added, Your Honor, and it seems like the dispute here is now getting away from goods or services and is more sale or lease. I'm happy to address both, but the comments I heard and Meta's reply, they're kind of zeroing in on sale or lease more than goods or services. So I'll spend my time on sale or lease, unless the court has concerns with it being, these platforms being goods or services. I think, as we've argued in our papers, they're goods, services, or some combination thereof. And that is a very factual issue. I heard a lot of fact issues argued today and in the papers. And just a reminder, Buzz Stew and 12B5, the court needs to accept all the state's well-pled allegations as true for purposes of resolving this motion. And just because Meta says the facts are X, Y, or Z, or could be X, Y, or Z, is completely irrelevant. And frankly, all the fact arguments show that we need to get into discovery before the court starts ruling on a lot of these complex issues. This is, I think we addressed it previously in the court's questions today, bear it out. This is new technology. The courts are always a little behind what's going on out in the marketplace. And I think that is also true with these social media platforms. The court asked the question whether the restatement deals with social media platforms. It doesn't, but it gives the framework, and I'll get to that in a little bit. But back to sale, Your Honor, if you look, these are defined in the NRS 598 statute. 0.094 defines a sale. It includes any sale, offer for sale, or attempt to sell any property for any consideration. Okay. And then property is defined in 0.0937. Property means any real or personal property, both real and personal property, intangible property, or services. So we heard a lot from Meta about how everything has to be tangible, and I'll get to that in the product liability causes of action as well and why that's wrong. But the statutory definition of property includes intangible property and services. Meta's platforms clearly meet that definition. So now it really just turns on consideration. And consideration can be anything. I'm sure the court is aware of it, and we've talked about dictionary definitions, Black's definitions, and those definitions make it clear that consideration in its broadest sense is the reason, motive, or inducement why any person is moved to bind themselves to another person in any type of agreement. And we just heard Mr. Hester argue that there's these contracts out there. Well, contracts require consideration. So if they're going to argue that there are terms of use contracts in place, then there's consideration on both sides. And I think it's pretty obvious when you look at the state's complaints. The states have alleged there was consideration. I think that there's sufficient allegations in the complaint to require the court to accept all of those allegations as true. Anything leading up to good or service for sale or lease, there are sufficient factual allegations to support that under Buzz Stew, and we should get into discovery. And if the parties discover something else, someone can file a motion for partial summary judgment down the line. But these are very fact-specific issues that are not appropriate for a Rule 12b-5 motion. Your Honor, I already addressed publisher. Did the court have any questions on opinion or puffery or the Nord-Pennington doctrine? I think that was adequately briefed, but
I do not have any specific questions. Let's listen to what everybody said. Questions I was gonna ask.
okay. Well, Your Honor, the complaints contain nearly 30 pages of misrepresentations that Meta made that it knew were false or had reason to know were false regarding the safety and quality of its products and those products' design features. Nord-Pennington simply does not apply at all outside the antitrust world, and this is not an antitrust case. So, Your Honor, happy to move on to product liability. I want to be sensitive of the court's time being in trial, but maybe before I leave deceptive trade practices, I'd like to ask if the court had any questions on that particular cause of action or those causes of action.
I'm gonna circle back to the same.
Okay. Thank you.
So. Are you contending that Meta's determination of how to interpret the complaint is wrong, and so therefore you do include sale or lease under the statute?
Yes.
It just, if you could just hone in a little bit, it wasn't exact. I mean, I read what everyone was saying. Other than, it just wasn't clear specifically on how you were addressing the sale or lease issue in response to that.
Sure. So this is interopposition. So sale or lease. Sale is defined in NRS 598-094 as any sale, offer for sale, or attempt to sell any property for any consideration. So now you've got any property for any consideration. Any property, the statutory definition includes specifically intangible property or services. I don't think, I mean, everything I heard from them today, they're trying to fit their platforms as being tangible, which I'm not sure I agree with, and I'll get to that in a minute on the product liability. But I didn't hear them arguing that the Meta platforms aren't at least intangible or services. They keep calling them services. So they fit under the statutory definition of property, which is then used in the definition of sale. And so I think it all funnels down to consideration and whether the use of these products and the exchange of user data for the privilege of using these products. And the court asked, could someone send a message to somebody else on a Meta platform without an account, without agreeing to share all of their data and whatever data Meta takes from these people and then stores about them and uses against them down the road? That's the question. Is consideration. There is not any Nevada case that says a quote unquote free product or service like this is not subject to deceptive trade practices. The state has alleged extensively in its complaints and then briefed that Meta is trying to induce people to use its platforms as much as possible so it can mine data and information about a person's likes and dislikes and activities and location, age. All of these factors go into the mix so that Meta can then use that data and monetize it with advertisers and others. And so they make their mousetrap as attractive as possible. So everybody wants to get on and see. They use these design features, and I won't get into them. We did it more in the last hearing, but these you never know what you're going to get when you log on. And the endless scroll, it's the slot machine thing, why people pull it. It's the same concept. People don't know what they're gonna get, and so they want to keep trying because maybe they'll get something really good. And so you refresh and you log on at all hours of the day and you stay up all night scrolling because you never know what interesting thing might pop up. These are the things they're doing. And the reason they're doing it is because they want user data. And the users get to use the platform. And it's not for free. It is not for free. They are giving up their data, and the court knows data is very valuable. Look at these companies. They make billions of dollars a year with that data. And it's in our opposition. Meta admits that virtually all of its revenue is generated from the data it mines from its users and how it uses that and monetizes it. They make literally billions of dollars. They're $1 trillion company off the backs of their users' data, including Nevada users. So to say that is not valuable consideration is just false. Meta thinks it's valuable. It's incredibly valuable. It's one of the most valuable things on the planet right now.
Isn't Meta's contention that there has to be consideration between the user and Meta, not how Meta ends up using users' information? So the court should be looking at that timing of when someone signs up for Facebook, right, or gets an Instagram account, whatever.
Sure. Well, the terms of use, we heard Mr. Hester say that there's consideration because there's contracts. Well, the contract is the terms of use. When someone creates an account and they scroll through whatever and say, agree, all those terms say, we are going to take your data and use it. And they have to, I think people can have different levels of what data they want to share. And there are different settings, but it's in our opposition, the terms of use and what Meta tells people it will be doing with their data. So that is the consideration. If Meta is going to say there's a contract, and contracts require consideration. So they can't have it both ways. They can't, sue a user to arbitrate in Timbuktu based on a term of use contract or agreement, and then turn around here and say there's no consideration for use of the services. I mean, frankly, if they were to prevail on that argument that there's no consideration, they should not be able to enforce their terms of use against any user ever, because then it's an illusory contract. There's no consideration being provided on both sides. But I think if the court looks closely at the definition of consideration and how broadly it is construed under the law, consideration is anything that somebody gives up to get something from the other one. Here, users are giving up their data and allowing Meta to track all of their information on what they do, when they do it, where they do it from, their age. Meta encourages you to put all sorts of information in about yourself. They do that so they can use that. And that is the consideration that users are giving. And Meta is giving its platforms. So hopefully that addresses the court's
Question. Thank you.
questions. Okay, thank you. I'll try. I know I'm getting a little bit short, so I'll get to the product liability. Your Honor, the state added significant related to the court's ruling, and it was a very narrow ruling. This is another one where Meta stretches what the court actually did. The court on the product liability causes of action simply just ruled that the complaints did not adequately allege that these platforms were products under Nevada law or a reasonable extension of the existing Nevada law. So the state did that, and we've cited the paragraphs in our papers. But one that I would like to talk about, I guess maybe I'll step back. It sounds like everyone agrees Schuler controls the court's decision on this issue and the restatement of torts. And Schuler says it should be a case-by-case approach. That's the superior methodology because it's versatile and allows courts to, quote, adjust for changes in technology. Well, that's what these cases are. This court is confronted with massive changes in technology. There's not going to be any example in the restatement that is exactly like it. But what I will say is that the restatement, and we've put it in our complaints, is quite clear. This is even the restatement third where it's talking about tangible. Nevada has not adopted the restatement third of torts. It's Schuler's talking about the restatement second of torts. And
Because didn't Schuler reject that, because that's what, didn't even mention there was amicus brief to adopt the third, and they said no.
that's right. That's right. So the second is more flexible and the policy considerations, all of those things. But even the third limits it to tangible personal property. And I think this is interesting though, Your Honor, it's in our complaints that even the third restatement third says that electricity is tangible property and considered a product because it is distributed commercially for use or consumption. And the state, this is in the messenger complaint, paragraph 551. And I don't have the exact numbers for the other allegations, but this same paragraph is in all three complaints. And the state has alleged that Meta's social media platforms, if electricity may be a product under the restatement, then these platforms can as well. You have users downloading the software onto their devices. It is saved. It is on many devices in this room right now, I'm confident, some or many of Meta's platforms. So they occupy physical space on hard drives. It is the modern equivalent of going to brick and mortar and buying software and putting it on your machine. That's alleged. Then that software on devices located in Nevada takes data, sends data to Nevada, and then takes data from Nevada, from the users, when they log on, when they sign up, all of those things. All of that data is like electricity, is transmitted through physical infrastructure in the state of Nevada. And we allege this specifically. You've got servers, cables, data centers. So just like electricity, natural gas, water, those sorts of things, Meta is dependent on physical infrastructure to deliver physical infrastructure in Nevada to deliver its products to Nevadans, and in order to get the data back from Nevadans and then use it for massive commercial gain. Those are the allegations of the complaint. And again, I think just the fact that the court has that before it shows the fact rich nature of these issues, that the court cannot say beyond a doubt that there's no set of facts that could ever support it. So dismissal under 12b-5 and bus stew would be improper under these facts and under the policy considerations of the second restatement as articulated in Schuler. I'm happy to go through those policy considerations, but it's basically Meta created these products, made them available in the stream of commerce. They are massively used throughout the world, including Nevada. And Meta should bear the burden of any harms caused by these products or defects in the products. And the state has alleged numerous specific defects that Meta created in these products and did so knowingly for financial gain. Those are the exact types of facts that fit within the purposes of product liability. Your Honor, we also have a section in our papers and in our complaints about Meta routinely calling its social media platforms products. They say it, they've said it under oath in this case. Mr. Archibong and Mr. Winters, both under oath, repeatedly call them products. Mr. Archibong's title is Vice President of Product Management at Meta. We also cite in our papers that Meta has told the SEC in SEC filings that these products are in fact products. So I think the court could take judicial notice of that. And frankly, Your Honor, at the last hearing, I looked at the transcript and Your Honor made a bit of a comment and said, well, if you can't take a defendant's own language for what it calls its, whatever it's selling, creates an interesting challenge on a 12b-5 motion. I agree. It does create an interesting challenge. I think it's a fact before the court. The court has to accept it as true. if we do discovery and something changes, Meta can file a motion for partial summary judgment. But at this stage, there's more than enough to support that these platforms are products, or at least under a reasonable extension of the law to accommodate new and changing technology as acknowledged by Schuler or encouraged by Schuler, that these causes of action should stand at this stage of the proceeding.
Which is gonna lead me to my. Does the state have the authority? Is that where you're going?
That is where I'm going. I was going to briefly mention unjust enrichment. The unjust enrichment ruling from Your Honor in these cases before was simply a matter of standing. Does it, and I think it was articulated by Mr. Hester, but the court's orders say, is the state saying Meta was unjustly enriched at the state's expense or someone else's expense? And I think it's both, but it's largely the users as well. And that's where it comes into parens patriae and standing. I don't hear Meta even contesting the state's ability and ability to pursue the Nevada deceptive trade practices causes of action on behalf of the residents of Nevada. Mr. Hester said when he
Vice
was,
liability, unjust enrichment and negligence.
Yeah,
Third, fourth, five, and six.
yes, he said 3 through 6 when he argued the parens patriae standing issue. So that's really all we're talking about, the common law. I know I'm going a little longer than I had hoped, but I think I can shortcut this, Your Honor, because the statutes make it clear, and these are cited not only in our complaints, but in our opposition papers as well. We have NRS 228.310, that's the creation of the consumer's advocate. Then you have 228380 sub 1 that says the consumer's advocate may exercise the power of the attorney general in areas of consumer protection. As a reminder, not only is the attorney general bringing this action, Mr. Figueroa, the consumer advocate, is also bringing this action. So that position with the state is in the case in all the complaints. It's right up front in paragraph 1. And then this is important, Your Honor. NRS 228.390, representation of public interest and consumers' interests. Subpart 1A, the consumer's advocate has sole discretion to represent or refrain from representing the public interest in any class of customers in any proceeding. And then public interest is actually defined in NRS 228.308. In Nevada, public interest means the interests or rights of the state of Nevada and of the residents of this state or a broad class of those residents, which arise from the Constitution, court decisions, and statutes of this state and of the United States, and from the common law, Your Honor. Product liability counts 3 through 6 are all common law claims. And the statutes expressly authorize the attorney general and or the consumer's advocate to pursue anything on behalf of the state or consumers in this state that touch on the public interest, and public interest includes the common law. Counts 3 through 6. So I think that puts all of it to bed, and I don't know why Meta has chosen to completely ignore those statutes and act like they don't exist. They do exist. The state has this standing to do it under an express statutory grant of authority here in Nevada. Then moving beyond that, the Supreme Court of the United States in SNAP, I believe, does control it. I don't understand Meta's argument that the Supreme Court of the United States discussing parens patriae standing in great depth and talking about states' quasi-sovereign interest and how they do not need an express statutory grant because they have an implicit right to protect the interests and their sovereignty. So that's the SNAP decision. We've briefed it. The state does have a quasi-sovereign interest. It has to be an interest separate from, it can't be just a nominal interest. And so here, And what the SNAP court tells us is that a quasi sovereign interest for a state is in the health and well-being, both physical and economic, of its residents. And that's this case, Your Honor. The state is bringing these causes of action, these cases against Meta for harm to the mental and physical well-being of the state's children and their families. I don't know how much stronger of a quasi-sovereign interest a state could have than in its children. It's the future of this state that the state is trying to protect. And the state clearly has a right to do that. And in the cases we cite, the Puerto Rico one, there's 3 million people in Puerto Rico, and the court said the state had a quasi-sovereign interest in 787 workers who were being discriminated against. So even in that such small fraction of the population, the Supreme Court said that standing existed, parens patriae standing. Here, it's a much larger fraction of Nevadans, all children and their families. That is a significant portion of the state. The state clearly has a quasi-sovereign interest in the health and well-being, both physical, mental well-being, and economic well-being of these individuals. And Your Honor, if the state has these interests, all of these causes of action stand. There's no basis to dismiss them on lack of standing. The state has adequately pled its standing. If something comes up down the road, Meta can challenge it again, but the state has added significant allegations about, and I do want to clarify the record here. Meta said it today in court and in its papers that the state did not amend its unjust enrichment cause of action. That is not accurate. The state alleged, let me see if I can find it here. The state has alleged I can't find it, but they've alleged a widespread.
You're referencing document 263, 264, 266, which are the three amended complaints.
Oh, here, I just found it. The state has amended.
Which one? You want?
This is, this is our paragraph 40 in the messenger complaint, 42 in Instagram and 40 in Facebook. But the state added the allegation of a widespread and devastating injury to Nevada's children, to their parents, and to the state's economy as a whole. I think that's a pretty material factual allegation, Your Honor, and it ties in with parens patriae standing and the quasi-sovereign interest. So paragraphs 40 in Messenger and Facebook and 42 in Instagram. So it's just not accurate that the state has not amended anything related to its unjust enrichment cause of action. But again, because the state has an express statutory grant of authority to bring common law claims on behalf of itself and its residents, I don't even know that the court needs to get into the quasi-sovereign interest analysis. But if the court decided to do that, that also supports the state's parens patriae standing to bring these causes of action. It's certainly sufficient to get by a motion to dismiss under 12b-5 and Buzz Stew. Meta has not met its burden to show that there could be no set of facts that would ever support the state's causes of action. The state has significantly amended its 3 complaints to address the court's narrow concerns and rulings in the prior orders. These cases should move forward. We should proceed to discovery and move forward with discovering all facts necessary to support the cases. Happy to answer any other questions the court has. Thank you.
Okay, is one person taking the final round?
Your Honor, if it's agreeable, we might just have 1 point from each of the 3 of us.
Okay.
We'll go quickly.
Hold on just 1 second. Yeah, yours.
5.
Okay, feel free.
Thank you, Your Honor. Very quickly on parens patriae, counsel said that the consumer advocate may, quote, exercise the powers of the attorney general. That's the point. legislative powers, the legislation enunciates the powers of the Attorney General to assert a parens patriae claim, and that's stated in the Ryan case out of the Nevada Supreme Court. The powers and the duties of the Attorney General are to be found only in legislative enactments. Now, there is clearly an enactment that permits the Attorney General to bring a claim under the Deceptive Trade Practices Act. By implication, clearly, that doesn't extend to other causes of action that are not enunciated in the legislation. And there is no statement in the Attorney General's powers of some broad ability to assert common law parens patriae claims. In fact, it's quite clear that under the Frito-Lay case that we discuss in our briefs, parens patriae was not a recognized common law concept to bring damages claims on behalf of consumers as are being asserted here. This is something that's a creature of statute, but the most important thing is Nevada law controls here. The federal law on standing to assert claims in federal court under SNAP or other cases does not control the question of the Attorney General's authority as a matter of Nevada law. And the Ryan case makes clear that's a creature of statute. And there's no statute the state points to that gives them authority to assert these three kinds of claims.
Are you contending that the Nevada Supreme Court or the Nevada Court of Appeals has ever said that the state could not pursue claims for product liability, unjust enrichment, or negligence? Because I can think of some cases, it's again, maybe before this court, which I'm not, this is different facts, but this is a global concept question. So yes, I can use other cases that have been before the court because it's whether or not the appellate courts have ever allowed those cases to go forward. So you're saying that there's no case, this is coming back, no case that has allowed a negligence claim, products liability, or an unjust enrichment claim to move forward under by the Attorney General?
On a parens patriae theory, we're not aware of any Nevada case that is so permitted at the appellate level. And
Opioid?
I don't believe those cases ever got to the appellate level, Your Honor.
Well,
I mean,
phrase, I say, I probably should have phrased it is precluded, not necessarily that it got to the, was ever precluded.
we're reading two cases together in particular, the Ryan case,
Okay.
which says there has to be legislative authorization,
I do.
and the State v. Moore case from 1922 out of the Nevada Supreme Court, where the court said if the legislature had intended to confer upon the Attorney General a power so great as to enable him, in that case, to intervene in a divorce suit, it would have expressed its purpose in a special statute. So we put those together to say Nevada law contemplates that the Attorney General's powers and authority to assert a parens patriae claim are defined by statute. And I think you can see that by implication in the fact that the Deceptive Trade Practices Act specifically provides for the Attorney General to assert a parens patriae claim. Well, there's a negative implication out of that. The state has not cited a single Nevada case at the appellate level that has permitted a parens patriae claim to proceed on these three causes of action. And conversely, because there is a specific reference to parens patriae actions in the Deceptive Trade Practices Act, I think there's a necessary implication that the Attorney General doesn't have that power. And we're told by the Nevada Supreme Court that the powers of the Attorney General are defined by statute.
You heard counsel say they did modify. You made a statement. Do you agree or disagree? You had said that they had not modified the unjust enrichment claim and given leave to amend. Counsel for the state disagreed. Did you have a chance to confirm?
I do not think that is correct, Your Honor. We had stated this in our opening brief and we reasserted it in our reply. I don't think paragraph 40 that counsel pointed to in the messenger complaint does anything to address the point that the court made previously, which is there is no allegation that Meta was unjustly enriched at the state's expense. That was the rationale the court expressed in its prior order. Paragraph 40 doesn't speak to that. Paragraph 40 doesn't say that Meta was enriched at the state's expense. So I don't think it has anything to do with the reasoning that the court relied on previously in dismissing the unjust enrichment claim.
Okay, appreciate it. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Briefly on the Deceptive Trade Practices Act claims. Your Honor, I listened to my colleague from the state. I did not hear an answer of how there is a sale or lease under the plain and ordinary language of the statute. A sale is a transfer of ownership and title to property from one person to another for a price. A sale is a transfer of property or title for a price. There is no transfer here. There's still been, we can talk about whether it's intangible or tangible. It really doesn't matter. There's no transfer here. There is no exchange that is required for users to use the platform. The user's given the same access.
Since I'm at a motion to dismiss, right? Aren't you, isn't that an ultimate determination on the merits? Because like I was looking at paragraphs in the 50s, right? Like around 52, 54 of the Instagram one. And they say that there are sales, right? So are you saying I shouldn't accept that as true?
I don't have the,
52. Yes.
Go ahead, finish the rest of yours. You can answer at the end of your thing.
and I wanted just, okay, so 52 is about shops. 50 is about your account center where you can manage experience. So once you're on, yes, you can participate in shops. You can, if you want, you can participate in buying particular products from advertisers and virtual stores. So that's what their allegation is saying. So once you're on, you can participate in that. But I don't think that answers the original question under the statute, which it is a requirement to go forward on a claim to be able to have these basic elements alleged in a pleading. Is there a good or service for sale or lease? How have they done that? The complaint that they say, and this is from their complaint, they say Messenger does not charge money from its users for access. Facebook does not charge money from its users for access. That's paragraph 66 of the Facebook amended. Instagram does not charge money from its users for access. Again, these are taken directly from those complaints. What the state tries to do, is say, well, once they're there, I guess they collect information and then they monetize that. But Your Honor, that is not sufficient under the statute. A good or service for sale or lease. That is not what is happening with this provision of this free service. This is a free service. And I think that, if you take their argument to its end, I mean, I guess I'm struggling with if all you had to do to satisfy this idea of a good or service for sale or lease, if all you had to do is say, well, we're going to collect information that later on we may monetize, that opens up a world of different claims that I don't think the legislature has said explicitly that they're doing that. The legislature says that you have to show goods or services for sale or lease, and they haven't met that. These are the plain language of the statute. Where is the sale? Where is the transfer? Where is the user giving up something in order to gain access to Meta? They're not.
Your Honor, just a couple of quick points on rebuttal on the product liability piece. And the theme is really the same theme throughout. This issue of what is a product is a question of law. It's not one of semantics. It's not about titles that are used by statements that are used by witnesses. It's a question of law for the courts to decide. That means that additional factual allegations are not conclusive. The adds that they've made to the complaints are not conclusive of this question of law. They did add allegations. Some of those allegations were merely legal argument, which are again not the basis that you would look at, because you're going to look at the briefing to address the legal argument. But ultimately, the additional factual allegations are not conclusive of the legal question about what is or is not a product. And that's what the court has to decide at this juncture of the case. I will also say, briefly, there was discussion about electricity as akin to what we're looking at here. And we addressed that in full on pages 16 and 17 of our motion to dismiss. But at a high level, I think it makes the real point about tangibility, because they pointed to the third restatement and they said, oh, okay, well, the third restatement acknowledges electricity. Well, what does it actually say? It said other items such as real property and electricity are products when the context of their distribution and use is sufficiently analogous to that of tangible personal property. Again, it goes back to tangible personal property. And it goes further to explain that there are two categories of intangible personal property. The first is information and media, like books. The second are forces, like electricity and x-rays. These are different categories. Social media services are more like the first, the media that's expressly recognized in the authority that they want to point to. And I think that helps distinguish the worlds that are at issue on the question of whether something is a product or not. And then lastly, I just wanted to make the point that, again, as a question of law, this discussion about whether something's a reasonable extension of the law is not the question that's at issue right now. That's a question that comes up in a different statute related to sanctions, and we've addressed that in our brief. The question that the court has to address is whether under existing law, this is a product or not. Whether something has been is sanctionable or reasonable in a complaint is a different question than the question that we have at issue right now, which is whether under existing law, under the Schuler case, under the restatement second of torts, under all that, this is or is not a product.
Okay, I do have one question for you. Straight out of Schuler. Right. Schuler explains that the case-by-case approach also allows the doctrine to adapt to technological advances, right? It cites a Hawaii case. And it says it again, right? It restates that again before it goes into the substance. So if Schuler is saying you need to adopt to technological advances, then you're contending it doesn't give an inference that you should look at every single thing on a case-by-case basis. You're still saying it arguably still has to be tangible to be a product?
I'm saying that Schuler does say you should take into account technological advances and use a case-by-case method. But Schuler also says that in applying the restatement sorts case-by-case method, you need to use as guideposts, no matter how far down the road we get, no matter how many technological advances there are, you need to use as guideposts what's in that restatement second of torts to make sure that we're still aligned with the policy objectives of strict liability. And so no matter whether we have new technology, tangibility is still part and parcel and core to the analysis that has to be applied, because everything in the restatement second of torts that are recognized as products are tangible. Automobile, car, pesticides.
But counsel, I mean, isn't that in itself self-limiting, because the time when the second restatement came about, right? Social media platforms didn't exist.
It's true. I agree.
That's why it's guideposts, right? Not plain specific language, right? That case you cited, the Ford, right? Case involving the Ford, that was like from 1906, 1917. It was somewhere way before I was born. So doesn't the court have to use those? I mean, Schuler says, accordingly, we conclude that the case-by-case approach is a superior methodology because it is versatile, right? Permitting courts to analyze each case individually and adjust to changes in technology, right? And because it is consistent with the text and purpose of section 402A. Therefore, when determining whether an item or instrumentality is a product that falls within the scope of strict products liability, courts must, and they put that in italics, apply section 402A of the second restatement, including the public policy objectives of the doctrine, as well as the relevant precedents interpreting section 402A. And then it says that is not to say, of course, that courts are not permitted to use inappropriate definitions as guidance when determining whether an item is indeed a product for purposes of strict liability. And then it talks about restatement cleared and some other different things, but when it uses the language twice in a couple of paragraphs, all about technology, right? To adjust to changes in technology. And since that's such a more recent case, doesn't that indicate that our appellate courts are taking into account that technology-based, what do I call them? There could be technology-based products. It's not excluding the whole realm of, it's not giving social media platforms a pass. Are you saying it's not giving, if you call it technology, it's not a product? Because then with all online gaming, you're making a distinction between, okay, use this one before, brick and mortar, right? You know, the old one-armed bandits, the in mechanical slot machines versus the partially electric slot machines versus the completely electronic slot machines. Is there such a distinction here in the state of Nevada that one of those or two of those are products, not all three?
Yes, I think that the Schuler case itself incorporates and states explicitly that when doing this test, when applying this test, you still have to take into account and use this guidepost these tangible list of items. And the reason for that is because of why strict liability applies. It's not just because, oh, it's tangible versus it's not. There's a reason why the doctrine was created. It was created so that these physical items that could cause actual injury, there was recourse for people that experienced that kind of injury. This is a brand new and different type of thing. And I recognize there can be a variety of technologies that remain tangible and that development can occur. But what is stated in Schuler and what's stated in the second restatement of torts reflects that there is some limitation. And there's a good reason for that limitation, in part also because the information, ideas, and the content issue that is actually driving what the injury is in here should not be treated the same as a physical defect. And so in the Schuler case, it was a large sign. And there was a defect with the actual sign that caused someone to fall. There was a physical, actual kind of defect that happened there. The question wasn't about what was on the sign and somebody experiencing mental injury from what was on the sign. It's a different question. And it's a broader expansion of strict liability than what Schuler is talking about when it's talking about taking into account technological advances in the types of products that can be recognized.
So I'm sorry. Are you saying that social media platforms can never be products, nothing electronic or anything that has a electronic presence, right, can never be a product?
There are plenty of things that have electronic presences, like a physical computer, your physical phone. If the injury comes from something that is physically from that device, it has electronics and it has electricity and it has all of those features that are new technologies, but it still follows the rule that's in the restatement about what is akin to the tangible items that are there. There's still a linkage there. When you start getting out of the world of there being physical injury from some kind of physical defect, then you start expanding the world beyond what I think Schuler recognizes the expansion is going to be on the technological front. And I think the restatement
yes
third
or no
of
to my
courts.
question.
Sorry.
Is that a simple, mine was a yes or no question, right? Are you saying social media is gonna pass? They
Well,
cannot be products.
I do think that social media does not qualify as products under the law as described, under Nevada law as described by Schuler and as reflected in the second restatement. No, I don't think they are products. And I don't perceive that as, I wouldn't describe that as getting a pass. I would describe that as there are doctrines that underlie why strict liability extends to a certain level or not. The liability comes from an analysis that says we want this to be able to make it easier for people to sue for injuries relating to these tangible items. And that doesn't apply, and no Nevada court has recognized that should apply outside of what the second restatement has described.
You think it's ever come up? And some court has denied it?
I'm not aware of this precise issue coming up in some court having denied it.
Because that's the question I really was asking beforehand. Is anyone saying it's ever been precluded in the state of Nevada?
No, I don't think it's been precluded, but I think it is functionally precluded by how the Nevada Supreme Court described how far they're willing to go on what is and what isn't a product in the Schuler case.
Okay, appreciate it. Thank you so much. Okay, everyone had full up to be heard. Okay, I'm putting this on my Friday the 14th Chambers calendar, no surprise, right? I got to look through a lot of the things. Thank you for the excellent briefing. Thank you for the excellent oral argument. You all raised a lot of different things, and with all your cross references to cross references to cross references, you can probably appreciate I need to go back and look at some of the things that have been asserted, and whether or not they are where they are, as well as reading Schuler 15 times. I guess I'll read another 16th or 17th. Just, well, we'll look at that and everything. So I will, my inclination, like I said, is going to be put it on the 14th for a Chambers decision. No appearance is necessary. Nobody's telling me there's anything, I mean, Supreme Court's already ruled with the Supreme Court's rules, so nobody's waiting there. Is there any reason that the 14th is going to negatively impact somebody?
No, Your Honor.
No, Your Honor.
That is what I'm going to do. I wish you all a great rest of your weekend, whatever you all are doing. Thank you so much.
Thank you. I hope your
Thank
voice
you,
is
Your Honor.
better.
Thank you, Your Honor. Hope you feel better.